Welcome. We are visiting the provisions of Indian Evidence Act as to the documentary evidence. The point of attention being today is about the electronic evidence. Indian Evidence Act in its chapter 5 is enlisting the provisions of documentary evidence, and one special class of documents is the electronic records. The section 65A and section 65B are concerning this special class of records. Section 65A is regarding special provisions as to evidence relating to electronic records. The provision is special as it is a new category of documents coming into existence. New process of preparation of the documents is coming into operation, and as such the necessity for this special provision. The section reads as that the contents of electronic records may be proved in accordance with the provisions of section 65B. C. The chapter is of documentary evidence. The word used here is electronic records. Therefore, this word record in the reference to electronic, so electronic record as such becomes a one class with respect to which special provisions are being made. And these provisions are to prove the contents of such record. This provision takes us to section 65B. Section 65B of the Indian Evidence Act is titled Admissibility of Electronic Records. It is the permissibility as well as the admissibility both being taken up in section 65B. Therefore, to have a proper comprehension of the implications of these special provisions, we shall be through this text in the sequence in which it is organized here in section 65B. Section 65B in its first clause, in first part, reads as, notwithstanding anything contained in this act. That means it is a special clause and it is notwithstanding anything contained in the act. It is over and above the other provisions of the Indian Evidence Act. Any information contained in an electronic record, so this special provision is regarding the information contained in the electronic record. Therefore, this provision regarding information contained in electronic record is over and above the procedures and other legislative permissibility or restrictions in the Act. The information contained in an electronic record is a special category of record, and it is this with respect to which this provision is being enacted. Let us read again. Notwithstanding anything contained in this act, any information contained in an electric record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer. C. The information of the electronic record is being pointed, which is in a printed form. So it is not in the computers, It is not on screens. It is as is printed on a paper, number one. Number two, stored, recorded, or copied in optical or magnetic media. The word used is media. So it is a very wide reservoir. It is not simple a word with which some technical meanings stand attached in ordinary language. The word media, as magnetic media, as optical media, is an attempt to cover as to how the electronic record can be reproduced, can be carried, can be stored. So this particular clause is regarding information contained in an electronic record which is printed. So only that electronic record information, number one, which is printed on a paper, or it is stored, recorded, or copied in optical or magnetic media. Therefore, this document as such will become some sort of a media or a paper. So information printed on a paper will make it a document like any other documents, written script documents. And then the second is the media. So it will be a special class, special category of the documents which are in the script printed form or which are in a recorded, copied situations: stored, recorded, or copied. These are three adjectives: stored, recorded, or copied in optical or magnetic media, produced by a computer. So see here there is a reference that this copy, this store, this recording is to be by a computer, and then it is said hereinafter referred to as the computer output. Therefore, this information in a printed form on a paper or in a stored, recorded, or copied form in optical or magnetic media produced by a computer is being designated, is being named as computer output. Therefore, this clause, section 65B, is regarding computer output, that information in a printed form or in a stored form, in a copied form, in a recorded form is by a computer is being designated as a computer output. Therefore, computer output as such becomes a specific technical designation for the electronic records, shall be deemed to be also a document. So a definition. So document here in this context is being defined as computer output. Computer output is being defined as a electronic record information printed on a paper or stored, recorded, or copied in optical or magnetic form media produced by a computer. So these two terms, document in this context and computer output in this context, is going to be, as is clearly, explicitly pointed in this clause, shall be deemed also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceeding without further proof or production of the original as evidence, or any contents of the original or of any fact stated therein of which direct evidence could be admissible. Now see, this clause as it is making it permissibility and admissibility as a secondary evidence. The original evidence, the direct evidence as it is said, so the original evidence which can be directly produced is if leading to a situation when there is need to lead secondary evidence in respect of it, then in that situation, the admissibility being allowed, admissibility being sanctioned is as is stated as an information contained in an electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media. Therefore, this information printed on a paper or recorded, stored or copied in optical or magnetic media as such becomes a secondary evidence permissible and as a proof of such document, such content, such information as an evidence. So clause 1 is providing us a situation and the methodology and logistics for leading admissible secondary evidence in the form of computer output. Now, subsection 2 of section B, the conditions referred to in subsection 1 in respect of computer output shall be the following. Now, this computer output as well is being specified, shall be the following, namely. Now, it is here in subsection 2 of section 65B, certain situations have been legislated to be taken as the output, computer output. So the word computer output is being further specified. And the first specification as section 65B2A is the computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purposes of any activities regularly carried on over that period by the person being lawful control over the use of the computer. See, it is a very big range of realistic coverage. There will be a computer, it is going to be used, it will be under the lawful control, and the information is in the process of the regular activities. So it is in the form as there is a person, he has a control over a computer, and in the computer the information is being processed or is being stored for the purposes of any activities regularly carried on. It is just like if some information is being preserved on a computer, say in a bank or in any office, or say even during court proceedings, which are the regularly carried activities, and that computer is under the control of a person who is doing the activity regularly. Now, these words, as these are being used, information for the purpose of any activities regularly carried on, it is implying that the institutions, the individuals, or the groups, or any other collective counters, public counters, where computer is being used as a machine, as a tool for recording the activities. This record of such computer as its computer output is being specified here in section 65B2A. Further, as section 65(2)(b), during the said record, the information of the kind contained in an electronic record or the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of said activities. See, when we are transiting from our classical and orthodox method of running institutions' activities in a manual way by the individuals is being brought in our these electronic devices period. Then the electronic devices as designated as a computer. So when computer is being used in the regular activities, then it is with respect to said information fed in such computers, then those computers' outputs are being classified specifically as computer outputs in respect to which the admissibility of secondary evidence of the original is being permitted here. In class C, throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was out of operation during that part of the period was not such as to affect the electronic record or the accuracy of its contents. So it is wholly realistic situation as that the computer being a machine, and it being a machine, so it may not be in proper operating state over whole of the period. Therefore, the periods during which though the machine is not operating properly, but when it is not affecting the electronic record already fed in the computer. So the test only is whether the non-functional period of such machine, if is not having effect upon the accuracy of the contents. When the content is not affected, when accuracy of the contents is not influenced, is being not affected, then the output of such computer as well is admissible under section 65B. Now D, the information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of the said activities. So C, now this again is a coverage for the practicalities, necessities of replacement or substitutions, of complementing or supplementing of the machines. Therefore, this set of A, B, C, and D clauses taken together bring to focus as that computer is a machine. It is to remain in operative or not operative situations. During non-operating situations, the circumstances regarding the accuracy of the information is to be the test, but for that the information already fed in that machine as computer is to be taken as a computer output permissible for the admissibility as a secondary evidence, as a substitute for the original information of the computer, a machine. Now, in continuity, subsection 3, subclass 3 of section 65B reads, where over any period the function of storing or processing information for the purposes of any activity is regularly carried on over the period as mentioned in clauses A of subsection 2 was regularly performed by the computer, whether now see how the specific situations are being considered. A, by combination of computers operating over that period, or by different computers operating in succession over the period, or by different combinations of computers operating in succession over that period, or in any other manner involving the successive operation over that period in whatever order of one or more computers and one or more combination of computers, all the computers used for that purpose during that period shall be treated for the purpose of this section as constituting a single computer, and references to this section to a computer shall be constituted accordingly. This, as such, is a preservation and acceptance of the reality of functional setups of machines as computers, as a chain of computers, a set of computers, a number of questions, a combination of computers, or a combined computer network of a number of machines. All those machines as a single operating system are being defined and are being accepted as a single computer. So the output of such computer setups functional apparatus is a computer output as stands defined at the outset in subsection 1 of section 65B. Then any proceeding before where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, now see, it is here where the legislative acceptance as a condition for this mode of admissibility of evidence has been put under very strict constraints, and these constraints are to have a certificate, the legislative precaution to ensure the degree of accuracy of the computer output. A certificate condition has been put, and this certificate condition is with respect to A, identifying the electronic record containing the statement and describing the manner in which it was produced. So, certificate is to be submitted regarding the identification of the electronic record as to the manner in which the same was reproduced. B, giving such particulars of any device involved in the production of the electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer. The second aspect with respect to which the certificate is to be specific is regarding the particulars of the device involved in the production of electronic record appropriate in the circumstances for the purpose of showing that electronic record was produced by a computer. The third condition being put, the restriction being put, the requirement being made specific is regarding, the certificate is also to be regarding dealing with any of the matters to which the conditions mentioned in subsection 2 state and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device of the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate, and the purpose of this subsection, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it. So, in this clause, it further is made clear that the certificate is to be as the truthfulness to the knowledge and belief of the person issuing such certificate. Now, further, subsection 5, for the purpose of this section, now see, this section in itself is becoming a code. It is becoming self-contained as it is now specifying the definitions, specifying the features of the important technical terms availed for this provision. A, information shall be taken to be supplied to a computer if it is supplied there in any appropriate form, and whether it is so supplied directly or with or without human intervention by means of any appropriate equipment. B. Whether in the course of activities carried on by any official information is supplied with a view to be it being stored or processed for the purpose of those activities by a computer operated otherwise than in the course of those activities that information if duly supplied be that. Now the details of these restrictions in itself point out that this category of, of secondary evidence regarding computer outputs is full of such a large number of realistic situations that to ensure the truthfulness of the evidence, these all restrictions, conditions be put under a certificate and then computer output shall be taken to have been produced by a computer, whether it was produced by directly or with or without human intervention by means of any appropriate equipment. And that follows explanation. For the purpose of this section, any reference to information being derived from other information shall be a reference to it being derived therefrom by calculation, comparison, or any other processes. This class of explanation and the section on the whole deserves to be read class by class as it is providing special situations of admissibility of secondary evidence in respect of the computer outputs. Computer outputs being the outputs of a machine, and there is a big difference between a man and a machine. Therefore, the special situations relating the machine are being dealt with here to ensure the truthfulness, authenticity, accuracy, security, and all connected aspects of the secondary evidence being permitted in this section. We shall read it time and again. We shall be very specific as to the very large number of realistic situations with which we will be confronted while in reality of the trial such evidence will be admitted as its admission and its evaluation and appreciation is going to have legal implications upon the justice to be reached at. As such, this set of special provisions deserves to be appreciated in the context in which these have been legislated. Thank you very much.